I'm Alex Shahrestani, member for the State Bar of Texas AI Task Force. In this segment, we'll look at the legal landscape around AI regulation, what's already here, what's coming, and how lawyers can help shape the future of responsible innovation. We'll cover US and global developments, sector-specific risks, and the unique role attorneys can play in policy and compliance. Current efforts to legislate AI in the US in particular are lacking nuance, and that's largely our fault. As the risk-averse group who's refusing to use the AI, we don't have the tools to have a good conversation about it when advocating for our clients, drafting policies, and discussing these issues in public forums, which results in AI legislation that is overly broad or overly simplistic and might have all the best intents in the world and the best efforts that they can put forward in the world, but they're lacking that nuanced understanding. The only way to get it is to be using AI regularly, and you need to take your responsibility as a steward of the law and of policy to a large extent seriously in the AI sphere as you do in all other spheres. When talking about AI regulation, there's a lot of questions about whether it should be a broad framework or sector specific. I think it's a valid concern. I think the first primary concern is going to be actually understanding the AI. I know I probably sound like a broken record to you, but this is going to be foundational because these debates need to happen. The need for actual AI regulation comes from misuse, and a lot of misuse actually has outcomes that are already regulated. And that doesn't mean we don't need some tweaks because of AI usage or various new threats available because of AI, in particular scalability. But really the question is going to come down to what are those additional risks? In some cases, you're going to need some additional legislation. So, an example that comes to mind is perhaps cybersecurity. So when you do coding with AI, the code is pulled from, again, the entire wide internet and used to train the AI, and it gets its information from there. It's pretty solid at coding at this point, but there are some flaws that need to be addressed. And simple cybersecurity frameworks that have been used historically might not be good enough right now. So traditionally, a lot of cybersecurity, for those who don't know, is regulated by the FTC based on the NIST cybersecurity framework, which is simply a what is standard practice test. If you do the standard practice, then you are doing appropriate levels of cybersecurity. And the reason they do that is because mom and pop's pizza shop doesn't need the same level of cybersecurity as Google does. So they look at industry partners or industry adjacent players to determine, is this the right level of security? Because AI is pulling code from the big wide internet, it's able to pull malware, vulnerable code, unsupported code. All of these things are what introduces risks where you hear about data breaches. Additionally, people have been working to figure out how to game the AI system in order to make sure that their results are the ones that are returned. There are going to be certain industries where if you do a particular type of search, someone has optimized for that result. Because of that, threat actors who perform cyber intrusions, whether for nation states or for hacker groups or for criminal profit enterprises, can use those same mechanisms to introduce these vulnerabilities. And because of the industry standard guidance that controls compliance in cybersecurity, this might be an instance of a threat that is introduced to the system that is not actually covered by regulation. So this is a very nuanced, very in-depth topic that I don't expect anyone to really engage with me on, right? But the issue is understanding how the AI works, what its flaws are, and then applying those principles to specific industries to find the edges where additional problems might arise. Applying regulation to specific industries is particularly important in high-risk ones. such as healthcare, finance, and criminal justice. When law firms look to integrate AI tools into their workflows, they should think about how they're going to govern those processes as they put new technology into place within their systems. There's a number of different contexts that need to be addressed. For a typical attorney, the primary one is going to be vendor and partnership arrangements. So think outside technology provider, perhaps an of counsel, what have you. You're going to need to think about what obligations you're placing on them about your data. You're going to need to look at whether they are sharing the data with anyone. You're going to need to look at whether they are using the data to improve their own products and services. And you need to look at whether that data is ultimately returned to you and not retained by the vendor or partner. When you're thinking about how to manage your AI technology in regards to clients, disclosure is your friend. You can think about it if you're a privacy-oriented attorney, kind of like that. Basically, disclosure is your friend, options, opting in, opting out, providing those opportunities for your clients up front before you start using those tools is a good way to keep your firm and your license safe. Many of these tools are safe and secure to use, but as legislation starts to pass among various states, we're starting to see some of these obligations being put to the forefront regardless of the security of the tool. So in order to protect yourself, your practice, and your clients, ensure you get informed consent up front before sharing that information. Regulation doesn't have to stifle innovation. It can help build trust and sustainability. The articles and guidance in this section will help you stay ahead of legislative developments and think strategically about your role in shaping responsible AI use for law. Thanks for watching.